Okay, how many of you are starting to do your cut sheets? Okay. Okay, here's what I'd like you to do on your cut sheets. We're not doing the cut sheets right now to get you down to 2 pages for the whole subject. What we're doing the cut sheets for now is I want you from this point forward to be doing a cut sheet. Let's say we're in con law. 1 or 2 pages of the structure, the format, the approach, and the sub rules of law on a page, 2 pages. But here's what I want to add. I want you to start looking at questions and answers. I want you to look at a lot of the answers from the answer book, because when you do your cut sheets at this point, when they test First Amendment on this bar, they test it the same way all the time. Many of you are first-time takers. The problem with when you take the bar the first time is you're trying to learn this massive amount of law, and you're kind of learning it in a vacuum. We do a lot of questions in here. We've gone through a lot of answers, but I still am finding when I read your essays that although you might know the issue, they're asking it slightly differently, and you're not identifying it necessarily. I want to up your identification and watch the patterns. So when you make your cut sheet, let's say we're making it in constitutional law, and you're making it in First Amendment. Take a look, I got your stuff. Take a look at First Amendment as it's tested on the bar, and you're going to start to see the pattern. You're going to start to see that they test it the same way very, very, very often. So as you're working on your cut sheet for First Amendment, I'd like you to look at a couple of questions and the answers, but only look at First Amendment. Don't look at equal protection. Don't look at Commerce Clause, because you're going to look at those when you get there. But I want you to start getting acclimated to the universe of how they test this material, because it's pretty standard. For example, when I was reading your PR questions, they tested duty of confidentiality for an attorney. More than half of you missed attorney-client privilege. But if you look at how they're testing duty of confidentiality in PR, you're going to see that about 90% of the time it's combined with the issue of attorney-client privilege. And that attorney-client privilege is not as broad as confidentiality, but I want you to start to have more real-life application to this bar as you're doing your cut sheet. And make sure you put on the cut sheets the rule of law. Not every little rule, not 20 steps, but just the rule you're dealing with, because what we're going to do the last 10 days is take the cut sheets, make them into 2 or 3 pages for the whole subject without tremendous rules of law, because I want you to get those now. Because I was thinking about a lot of you, and I was thinking about, okay, you're studying hard, I'm seeing your exams, maybe you're first-time takers or repeaters, and you're not, they may ask it slightly differently, and that sometimes throws you off, but it's answered the same way. And I want you to start to see what they test and see what it looks like, and kind of take away some of this fear that it's overwhelming and that you can never sort of manage it or handle it. I looked at your performance tests. The first performance test we gave in here was Honebacker. I do think it's one of the hardest performance tests the bar has ever given. And you did amazing on it. You really did well. You did not make mistakes a lot of the other classes made. You didn't get caught up in the story. I was so impressed with you. You're coming along really nicely. You're getting there. Your MBEs are getting better. I just want to make sure that those essays get cleaned up a little bit, and that you know how when you're learning multi-state, you start to see how they test it, and then the next time you don't miss it because they test it landlord-tenant the same way, or they tested something the same way. I want the essays to be more doable for you. So everybody do that. And I don't want you to move back yet. I want you to move forward. In other words, I want you to do evidence for the exam this weekend. I want you to do con law for the exam this weekend. and I want you to believe it's real property this weekend, but I could be wrong. And then once you've done where we are and you're moving ahead, then you're going to go back and clean up into the cut sheets for torts and contracts and PR. The most important cut sheet to do in here, there's two: professional responsibility and civil procedure. Now, civil procedure is very cool because the bar tests like 12 topics and they test them over and over. Look at all the res judicata collateral estoppel questions in Civ Pro. You know, look at and you're going to start to see, you know what? No wonder there's lawyers out there that I can't believe pass the bar. Seriously, you're going to start to see how this fits into their way of asking you. Because I am seeing that in the abstract, some of you know the material, but then when they ask it a certain way, you don't recognize that that's a different way of asking it, and you're missing it. And you know it. And I know you know it because I've seen it in your outline of the question. And just the last kind of thing I want to say to you, but you're coming along nicely. You've made a lot of progress. This should start to bring it in more and more. And can you memorize everything? I don't want you memorizing everything. I want you to memorize the main headings, the elements to that main heading, and the rule to the elements. And that should be on your cut sheets. So that you're going to start to see that when they give you First Amendment, or they give you Commerce Clause, or they give you privileges and immunities, pretty much given the same way all the time. And I want you to look at how they ask it. And you don't need to do it closed book. I'm not testing you. So for the exam this weekend, let's try to do your cut sheets, try to look at the questions, look at the answers, and see if that starts bringing this in for you. Because now's the time. In the beginning, I didn't want you looking at a lot of questions and answers. You weren't ready. We're getting ready now. This is the time. And then I'll do the final cut in terms of what you need to do next week. Okay, good. Anything quick before we start, because I do have a lot to cover tonight. I'm going to go through evidence and con law. So, yeah, go ahead, Doug. Wills and trust would be perfect to do, because you had wills and trust last week. It'll give you a chance to catch up in evidence. You know, I purposely am going later on the schedule in July so you can catch up. But I still get the feeling you're trying to memorize too much. And I still get the feeling that you're trying to like just read it and memorize it. And that's why some of you look so exhausted. I want you to memorize it with your study partner, talk it out loud, do the cut sheets together, do it on a blackboard. I'm not testing you at this point. In other words, these cut sheets isn't to like test you. It's to get some interaction, to get you to apply this more realistically. And unlike law school, sometimes in law school they test one thing, teach something else. The bar's pretty consistent. It's like if you look at 5 driver ed driver's test, the written part, you're going to see the same symposium of questions asked the same way. What's the yellow sign? What does the red sign mean? How many miles in a school district? The same questions get tested a lot. They just mix them up. Okay, so with that being said, anything else quick before? And I'm assuming at this point that none of you are really fully outlining anymore, that you're doing your cut sheets. You needed to outline in the beginning because you needed to see how to see this picture, how to work with it. It's like dough. Once I know you can work with dough, now I don't need you to watch it rise. I need you to shape the loaves and roll it. Yes, you asked if we're going to have any more de-stressing things with Leonard. Tonight he has offered to do a stress management, which is inspirational to me, to end at around 9:30 so that he can do this with you, relax you, and then you can, drive home safely, have a great night's sleep, and feel more and more relaxed. There's a tremendous difference in the people that are getting relaxation from him, for the most part, and the ones that have not yet. So, yes, Leonard, you're a very important person in this process in many ways. Okay, anybody else? Okay, did I ask somebody to remind me to ask me this question? Was there a question I asked somebody to ask me? I thought there was, but okay, let's get started. Schedules, before we start, how are your schedules going in terms of your keeping up with your own schedule? Here's what's interesting. If you were to take one of the major big bar review courses, you would be doing your tests when you felt like it. You'd be sending them in and getting minimal feedback. You would not be 3 hours simulated bar, closed book. You are with feedback. You are so far ahead of everyone. I mean, you don't even get how far ahead you are unless you have friends doing other things and they've gotten their papers back, one of them saying can't read your handwriting, missed issues. You're doing performance tests, multi-states, and you're doing them under bar conditions. This bar, when it finally rolls around, you're going to call me during the break and say, thank God I did the simulated exams with you. I just pretended this was a sim exam for you, and I wasn't freaked out. Okay? Anything else before we start? Yes?
Are you grading the exam? Because the red marker that's amazing, can't read, can I buy them?
No. I know the one. The red marker that you can't read is the former bar grader. And his grades are higher than mine. When you see your grade slashed red out and lowered, that's me rereading his. Yeah, you know what, Anne, we need to talk to him about printing and making it clearer. Yeah, but he's the former bar grader. Yeah. You know what, we could, Annie, if he needs a package of, I have looked at, I read everything actually, and see how you're doing. If I don't know where you're at. I don't remark every test. Sometimes his grades are exactly right. If it's not scratched out, the grade was fine. There's not a rereader grade. If the grade is scratched out and lowered, it's always me. I always lower it. I'm the rereader. Yeah. When are you supposed to be done memorizing? That's a good question. Here's the thing. At this point, most of your memorization that you're going to do about the last 10 days before the bar is going to be a rememorization. I've pushed you so hard to memorize at least once. Take simulated exams at least well enough, you know it well enough to come and sit in an exam in this class and not get a 55, not get a 60, but do better. The last 10 days will be strictly saved for memorization and polish. Okay? But do you understand what it would be like for you if at this point you hadn't memorized anything and all your exams were open book? A, you would be crying. B, you're going to walk into this bar with somebody telling you, don't worry, all you need to do is understand this material. Have you found that to be true? You can't. It's great if you understand it, and it's great if that's during the bar kind of all you can do for a question. But that is not our standard in here, is that you simply sort of understand the law. Our standard in here is I've been building in memorization right along. I know how much you've memorized because I'm looking at your exams. And as a whole, you're not in bad shape at all. A lot of you are first-time takers. A lot of the repeaters are a little bit further behind than you are. You're a little bit more intense about it and more realizing you want to do this the first time. So I'm not trying to have you kick back at this point, but we're about, 3 weeks away? 21 days, and I don't want pedal to the metal right now because I don't want you exhausted. And seriously, when you say, memorize, are you saying like rememorize, Sharon, or are you saying memorize, you haven't looked at it, even known it for the first time? This is a good question. What she's saying is that when she memorized for the simulated exams, she memorized the main stuff, but there's sections she needs to go back and look at and memorize. That's the last 10 days. Because the stuff you've known pretty well, you'll just refresh, and you'll have time because you will be doing a subject or a subject and a half a day. What's going to happen, and we'll talk about this the last class, and what I did for you this time is I did a special last class wrap for you without sticking in a subject. Usually we do a subject and a wrap, but I knew you were a lot of first-time takers, and I knew that you would need maybe one extra, just kind of wrap-up class to get you going for this bar. But what you're going to find when you start to know it is that by day 6 of that 10 days, you know enough of this that you don't want to do 7 hours. You can do 5. And by day 8, you can do 4. Because once you know it, you know it. And you're looking at me like, oh, she's crazy. I'm not there. She's out of her mind. Trust me when I tell you that the last 10 days, each day will be fewer hours than the day before. Not unless you're one of these people that takes the bar, went to law school, crammed for everything the last 10 seconds. None of you are striking me like that, by the way. I didn't really see that kind of pattern in here. You know, I mean, the people that worked and went to law school, which some of you did, are those kind of people. They had to. They have children, they had jobs, they weren't able to do it. But you're pretty young for the most part, and I think you're going to be okay. But I think you're doing pretty well now because all your tests are closed book. And I'm not looking at this going, oh my God, their law is atrocious, they're not memorizing enough. Sometimes it is atrocious, and even the way you're making it up, sometimes I have laughed my ass off. I mean, like, roared. But A for effort for giving it a go, you know? You know, I mean, I just sit there cracking up, and you know, I'm in the room by myself. People want to know if I'm talking to ghosts or guides or angels, and I'm roaring with laughter. If your exam can make me laugh, it's a good day. I mean, nice creative try. Good for Hollywood and Washington at this point. You know, do need to know some of this law a bit better. Now, I do want to say one last thing before we get into substantive. There is going to be a bar question that does not fit an approach, does not fit a cut sheet. I want you to learn to be comfortable and trust yourselves. There's always one that you look at it and you go, what? And how you handle those is you head note, and you go in the order of the facts, and you make it clear. And you, even if you don't know the law, you head note with an issue, make up a rule, stick to the facts, quote facts. You've had so much organization help in here. Make it well organized, because the entire state, their exams are going to look like they're on, well, what's a good drug that's like hallucinogenic? Crack? I mean, you can tell I don't take drugs. Acid. Who said acid? Hey, really, that's kind of like a 60s drug, but yeah, it's going to, you know, the whole state's going to look like they're on acid. Crystal meth, whatever. Steroids, does that make you? There's all this, you know, wrestler, boxer thing going on right now with learning disabilities, and the child needed, you know, steroids at 7 because he had a weak X chromosome or something. What a bunch of BS. That's like saying the sentence was too severe for Gordon Liddy, right? Gordon Liddy, right? Liddy, isn't that funny? Oh, that brought it to mind. So, no, you're going to be calm. You're going to be structured. You're going to do what you know in here. All right, it's not your 90 on this bar. They don't even give 90s. May not even be an 80, which they rarely give. Most of their scores are between 55 and 70. 72.5, 75. A 75 is a fabulous grade. A 70, you're good to go. A 67.5, you're almost there. 50 and 55, taking the bar again. So what we're trying to do is get the good scores where we can get them and give you a net where you're nervous about it. Now, the funniest thing ever is the stuff you think you're nervous about, that the question was like something you just thought, where the heck is this coming from, ends up being your higher score. Because you worked through it, you paid attention to the facts, you didn't go on autopilot, and they loved it. And a couple people are nodding their head who've taken the bar before, looked at questions, even in here. Some of the stuff you thought you were not so good and you did better. Again, connection, oneness with the questions. That will save you every time, is oneness with the question. Okay? All right, let's do some evidence. Now, I have to tell you that I completely love evidence. I'm in love with evidence. And the reason I'm in love with evidence, as I fall over, the reason I love evidence is because, number one, it's really easy, because they test the same stuff over and over, and there's no tricks. There's no, I don't know what to write. It's like so clear what everything is. The thing that's hard about evidence, it's a racehorse. Evidence is always a racehorse. Now, the thing I want to warn you about in evidence is your timing. If you overwrite on morning number 1, question 1, so you're 10 over. Then on question 2, you're 5 over. So now you're 15 minutes down, and question 3 is evidence. You're in trouble. You're really in trouble. So you cannot overwrite on this bar. Watch your timing. Evidence questions will take you to the hour. Don't overwrite them. Don't go past the hour. Let's say question 1 is evidence. If you take an hour and 20 minutes on question 1 thinking, I am just going to kill evidence, and you can't kill evidence, you can't get a high enough score on 1 to make up for a 55 on 3. You really can't. If there's one thing I've told you, you've got to watch your timing in here. I still am hearing timing issues, and I see them on your exams. And people say to me, should I take these questions out of order? Let's say, should I do evidence first if it's the 3rd question? I am not a fan of you pre-reading the bar questions. If you're anything like me, if question 2 is trusts and wills, and I know I'm weak in it, I am really going to be worried the whole time about the question I'm weak in. I'm not going to focus on what I'm doing. Take each question as it comes. Focus on that question. When you're done, it's yesterday's news, last year's boyfriend, last year's style. It's Die Hard 1. You're over. You're done. It's Superman 1. He's dead. You know, you are, pardon me, I love him too. The handsomest man in the world. But here's the thing. Hour per question. So let me just say this about evidence. Evidence is one of those subjects you're going to need to study and restudy and restudy and rememorize. It's a lot of small rules. It's a subject you're going to need to revisit quite a bit, okay? So starting with evidence, everybody open your approach book. Now, what they've done this bar is they've added the California Evidence Code. The California Evidence Code, you can say CEC. The first time you bring up the California Evidence Code, say CEC. Generally, here's the reason they're adding the California Rules of Evidence. Because most people are practicing in California, and they're making objections in California courts using the FRE. And the judges are getting really upset about the fact that none of the people coming out of school know the California Evidence Code. So they're front-loading it into the bar exam. It's not that different than the FRE, but some things are different. So, on this bar, the first thing you need to pay attention to is whether they tell you you're in California. And I think they're going to be very obvious about it. This was filed in a California court. We're in California. Apply California rules. If they want you to apply both, they'll say apply both. I think if you have time, you should apply both because you want to show them that you know the difference. In this approach, I start with the FRE because your MBE is FRE. FRE are the Federal Rules of Evidence. So you need the federal rules for the multi-state, so we added California for the essays. Now, CEC is California, FRE the Federal Rules of Evidence. Now, there are 2 types of evidence question on the California bar. Type 1 is the traditional kind of question. And everybody open your question book. Everyone open your question book. Go to evidence question number 1. Everyone turn to evidence question 1. Everybody got it? Nod if you have it. Have it? Okay, read me the call, Spartak. Assume timely and appropriate objections were made to the foregoing. What that means is that you are to assume that the form objections have already been made and you don't make them. Form objections are the objections you make before you make your substantive content objections. Form objections, asked and answered. Form objections, compound question. Form objections, ambiguous, unintelligible. Form objections, leading. Form objections, calls for a narrative. Okay? This standard bar question, the form objections are already made because they tell you they're already made. That's what they mean by timely and appropriate objections. This is the old type, this is the traditional type. Remember on this type of question that the way to organize this is in your columns, and each column tells me what's being introduced or who's testifying. So column 1 on the and question would be Ann's first witness, Bob. Column 2 would be Ann testified, I'll settle with you. Column 3, Rick testifies photographs. Column 4, Dave introduces the shoe expert. In other words, in these questions, you must tell me either who's testifying or what's being introduced. One of the things I'm still noticing in your essays is you're not taking these calls literally enough. You're kind of shortcutting the call in your exam. I don't want you to do that. And a lot of you are typing, so it's pretty quick for you. This question is your traditional question. The form objections have been made, and you're going to go through the content objections, which is your PROPHET. Probative sufficiency, reliability, opinion, privilege, hearsay, examination, and testimonial substitutes. If you learn this approach, you will be hot dogs in court. I use this as a trial lawyer constantly. I used it on a television show. My objections were so fast, so quick, so accurate, the other guy wasn't even standing yet before the court was ruling. Now, here's another little trick, and maybe you're going to think this is not good. But another little trick is, let's say the other side's on a roll. You ever see the other side where your witness is on the stand and they're hammering the hell out of them, and you've got a jury, you've got a judge, and they're just hitting point 1, point 2, point 3, point 4, and their rhythm is perfect? Break their rhythm. Objection, Your Honor. I don't see the relevancy of this. Objection, Your Honor. This is the 3rd time they've asked it. Stupid question. Objection, Your Honor. Object, object, object. Throw their rhythm off. The other attorney turns to you, starts arguing with you. Well, we have never asked this question before. And you say, yes, you've asked it in 3 different ways. Do you think you're going to get a different answer asking it a different way? Then he goes back. He doesn't know where the hell he is. He's like, 1 moment, Your Honor. And he goes and he looks. Get him off his rhythm. Fire him up. Poke him where you know it's going to hurt. You know, don't let him keep ringing the point. Point, 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 point. It's like in basketball. Trip the sucker. Okay, now, this is legal. You know, don't be annoying. I mean, if the judge starts to give you that eye with the eyebrow going up, cool your jets a little bit. And then if he's scoring points, go, Your Honor, it's boiling hot. My witness has a young child. Can we take a 25-minute break? Did you notice in a lot of the high-profile trials when they took the break? Sometimes you take a break because you want that point to sink in with that jury where over lunch all they're thinking about are stab wounds. Okay? You just want to let them mull it over and mull it over. If the evidence is bad for you and the other guy's like, Your Honor, can we take a lunch break? And we're like, Your Honor, I only have this witness this afternoon. I'd love to break. Can I just get him on? You know, he's our ex, you know, just push it the other way. I told you, I had a witness one time, big professional, had a radio show, top expert, on the witness stand, and the male attorney was hammering her into the ground where you could hardly even hear her answers. I wanted to do slap therapy on her. So I said to the judge, Your Honor, I am hypoglycemic. If I don't eat something, I'm going to faint. What I really should have said, I need to beat the crap out of my witness. Can we please take a 15-minute break so I can get a protein bar? I throw her into the ladies' room and slap her. I don't slap her physically. What are you doing? What are you thinking? Why aren't you answering? What is wrong? I don't know. It reminds me of my father. Get out of that. Get over it. Get back on there. You're protecting a child. Do your job. Deal with your father later. Life's tough and then you die. You got a kid to protect here. Snap out of it. She gets back on the stand. The judge looks like, is this her other personality? So if you've got a witness that's just sliding under the table, fainting, being, whatever's going on, stop it and go on. But objections, believe me. I mean, Chris Darden, I love Chris. We're very, very good friends. We have dinner together. We hang together. We met on a show. And Chris is an Aries. And Aries are fire, and I'm an air sign. So I would just blow on him and explode, you know. So, you know, I would, and I knew how to blow on him. It was very subtle. I mean, you don't always have to go, you know, you could just kind of poke him a little bit. Well, I would poke him, and he would go crazy. And then the judge would go, Mr. Darden, because then he said, you know, Your Honor, there's too much estrogen in this room. Female judge, female client, I'm a female. And he said, you know, I just can't tolerate the estrogen in here. I forgot what I said to him. And she goes, oh, is that so, Mr. Darden? Well, how about I now take your right away of cross-examining your witness? I'm not only going to be the judge, but I am also going to cross-examine your witness. Because you have lost the right to stand up in this courtroom by telling me there's too many females in the room. I'm like, yes. Anyway, but my head is down. I look serious. You know, and I look at Chris, you know, sorry, Chris, you know, so not sorry. So the only problem with the judge cross-examining is to go, Your Honor, I object to the question, overruled. She's asking it. She's just, you know, upholding all of her own objections. So, you know, he gets kicked off that case. So you got to know your opponent and these objections. If you're having trouble, do what you need to do. You know, but be right about them. This is going to help you go boom, boom, boom. I remember going multiple hearsay, level 1, level 2, no exceptions. You're right, objections overruled, and the other guy is going through his some kind of something. I'm like, Sam, we're moving on here. We're past that. We're on the next thing. The judge is like, Sam, this is your witness. You know, and it looks terrible in front of a jury. Terrible. Looks like the guy doesn't know what he's doing. Be smart. But the way you be smart is to know the material. And I used my own approach, and it worked. So, this is question number 1. Question type number 2 is a transcript. They have added the transcript. Now, let's take a look at what a transcript looks like. Everybody go to evidence question 9, Phil's car. Okay, this is the transcript. The reason the bar has added transcripts is because they realize that what you're going to do is have real testimony in a real court, and you're going to need to move and object and do all that. Now, transcript type questions require that you make the form objections. Because notice, read me the call, Spartak, on 9. Notice they don't tell you all the objections have been made. When they tell you the objections have been made, those are the form ones that are made. Obviously, you have to make the content objections. Here, they're asking you to make the objections. You would organize this by going through the numbers. Number 1, traffic division for 16 years. Make sure you tell your reader where you are. Okay. Number 2, Phil drove the red car. Always let your reader number exactly according to this and let them know where you are. But these are going to be the first objections. Not always, but the first one usually is, like I remember, saying to a witness, if it was on my side, so tell me everything that happened. Of course we'd practiced it 5 times before I put her on the stand. Prepare your witnesses. You're not going to tell them what to testify to, but you are going to say, that's not important, that's not important, that's not important. Okay? What can you go, okay, Sarah, tell me everything? No, that calls for a narrative. So the form objections get made first, then the content objections. Okay, now, this is important to what I've just said to you. Now, yeah. Okay, his question is, since the transcript style, how often? at least anytime evidence is tested, okay? Evidence is not tested on every bar, but I would say the transcript type question is running 2 to 1 to the regular question. Now, the only reason that may be different this time is they're adding in the California rules of evidence, and I'm not sure they're going to want to pile in everything, but you need to be prepared for both types of questions. Okay, now, so let's talk a second about the form objections on page 5. What I've done for you is I've given you all the objections and the rule of law. All the objections and the rule of law, okay? So I just want to go through these with you quickly. The most heavily tested on page 5 is ambiguous, unintelligible. Argumentative. Like argumentative is something like, now you know you didn't test that drill before you used it. Okay, asked and answered is heavily tested. Very heavily tested is assumes facts, not an evidence. The question will assume that the lawyer has already introduced and laid the foundation. That one's tested a lot. Calls for a narrative is pretty obvious, so tell me everything. I'm the queen of compound questions. I am the queen of them. So, Janet, isn't it true that you walked to the store, you bought milk, then you went home, and then you stabbed your husband? Yes. Okay. Most lawyers don't get on me for that. They just don't. I don't know why. The judge will kind of, and then sometimes the judge will say, counselor, is there anything here you want to object to? And I'll be shaking my head like, no, you don't want to. Okay, and the jury will be looking at me going, the jury watches every single thing that you do, and they tend to rule in the favor of either the client they like the best or the attorney they like the best, because half the evidence is incomprehensible and way above the ordinary intelligence of the average juror, including myself. I mean, I could no more do a merger with a corporation and $1 billion and stock options around the world than I could, do the square root of 27. Demonstrative evidence lacks foundation, so. Leading, heavily tested. Can you lead on direct? You cannot lead on direct. That's another, unless your witness is hostile. That's another famous trick, is to lead your witness through everything. But they'll catch you on it. You can lead on cross, and you better lead on cross. And one of the things you do on cross is to give them only yes or no. Yeah. On the bar, they don't really try to trick you. They're very obvious. The bar, his question was, does the bar try to trick you on leading questions for generic things? Like, tell me your name, tell me where you work, tell me how long you've known. Those you can lead on. On cross, I just, limit exactly what you want and give them yes or no. And if they start telling a story, Your Honor, I object. I've asked the witness to answer yes or no. Yes or no. And then you get in their face. And then they try to kill you, like one guy tried to kill me. And he'll go, you might want to stand back. We were shooting a pilot, the guy tried to kill me. He didn't pay child support. He didn't like that. Okay, non-responsive, not too often. Lack of foundation, very heavily tested. They'll ask a question, but they won't lay the foundation. And speculative or lack personal knowledge, very heavily tested. So I've taken all of these and boiled them down to the small amount that you really need to know that are tested frequently. Yeah. I'm not understanding you. On type 2, you mean transcript or the typical transcript question? Ask me again. Yeah. Yes. Yes. Can you object to an answer? How about the answer's non-responsive to the question? Your Honor, I asked him what time of day it is, and he's telling me the guy drove a red car. Motion to strike, non-responsive. Yes, you can also object to the answers. Yes, of course. Look at the question, but it could be non-responsive. It could be argumentative. It could be, plenty of things you object to the answer. Now, Okay, so these are then on the transcript questions, you do the form objections first, then you do the content objections. And content objections, the approach is on page 9 and on page 10. If you memorize this and go in order, I promise you in a court of law, you will be so fast and so accurate. And then under the hearsay exceptions, if you memorize the mnemonics, you are going to be really quick, accurate trial lawyers. Okay, now let's start on page 11. I'm going to have you highlight what's important. I'm going to say the next most important thing that I've said tonight. Your first content objection always is relevancy. Always relevancy. Now, at one of the law schools that some of you attend, I gave a consultation to the faculty. And the dean asked me to give them a bar question and have people do it. Because in order to help you pass the bar, the school faculty needs to know, some of them are at Harvard, some of them are out of state, some of them have never taken the California bar, and they needed to know. Well, I had the evidence teacher take an evidence question and send it to me. He got a 60. The guy went to Columbia and is a great teacher. Why did he get a 60? He left out relevancy. And I said, what are you thinking? And he said, I thought you only talk about it if it's an issue. I said, it's always an issue. The discussion's over if something's not relevant. We don't care if it's not hearsay or care. If it's not relevant, game over. Relevancy, so here's how you're going to handle it. You're going to say that under the CEC, if it's for California, under CEC section 350, no evidence is admissible except relevant evidence. Then you're going to say evidence is logically relevant if it tends to prove or disprove a disputed fact of consequence. You are then going to tell your grader that the disputed fact of consequence here is. You're going to go straight there. That the blue car ran the red light, and thus the accident was Jane's fault, and therefore this evidence is relevant. Let me do that one more time. If you're in California, you're going to start with CEC 350. No evidence is admissible except relevant evidence. Your next head note is logical relevancy or relevancy. Evidence is logically relevant if it tends to prove or disprove a disputed fact of consequence. Your next sentence is, here the disputed fact of consequence is who caused the accident, who raped Tess, who broke through the store window, who was at fault. This evidence tends to prove or disprove that disputed fact of consequence because. Now, don't be sloppy as to whether this is relevant or not. A lot of times, it's not relevant evidence. And if you blow past this, the bar knows you're not paying any attention. Now, once you define it the first time, the next heading you can say, this evidence is logically relevant because the disputed fact of consequence is, and this goes to that fact. The next time you do it, you don't need to fully define it again and again and again, unless you're typing and you can cut and paste, cut and paste, cut and paste. But you can say, the disputed fact of consequence here is who left the water stain on the floor in the movie theater. This isn't important because it goes to show who's at fault, which is the disputed fact of consequence. All your evidence questions, other than the form objections, are going to start with relevancy. If you can handle that, they know you're pretty good. Yeah. It's basically, I would start with just relevancy. Do the California 350 and then go forward. Now, logical relevancy tends to come up substantively with circumstantial evidence. The bar has moved away from testing a lot of this. In other words, they used to test other accidents under similar conditions. they use to test negative evidence, where somebody will introduce the fact that nobody has slipped on the floor in the theater all week. Therefore, it shows that everyone is cleaned up, so our plaintiff didn't slip last night. The thing they're still testing is foundation. Heavily tested is foundation for scientific evidence. Like in tonight's question, foundation for scientific evidence. And if you have identification of physical evidence, heroin like tonight, a gun, a shoe print, first of all, you have to lay the foundation and prove chain of custody. Just like the O.J. case, do you remember there was a big deal because one of the police officers took the vial of blood home with him and they couldn't show that it hadn't been tampered with? And rightfully so, they couldn't show it. Police officers are not supposed to take the evidence home with them. They're supposed to put it in an evidence locker at the station. You know, rightfully so, they didn't do that. So chain of custody, you're going to have to show that where the substance was, in whose possession, and you need to make sure you link it up at every stage where that substance was to show it wasn't tampered with. The CEC requires that you show what the item is, that it's relevant to the case, that it's in the same relevant condition, and again, chain of custody. Unbroken chain of possession. Physical evidence, scientific evidence also has to be authenticated, because if it isn't what it purports to be, it's not relevant. If it isn't what it purports to be, it's not relevant. So, you have to lay a foundation. Okay, and the foundation has to be, let's say, it has to be who it was made by, who made the report, who it was done with someone with personal knowledge, truth and accuracy, and a witness is available that has personal knowledge. And then you have the Daubert test, which is that the scientific test is recognized by the scientific community. For example, astrology is not recognized. Okay? Was it properly administered and the results were interpreted by a qualified expert? This is asked all the time. And it's very obvious. In tonight's question, it was heroin. And he said it was powdered milk, and the state police lab says it's heroin. You have to show drug testing. You have to show, was it who was administered, and were they interpreted by a qualified expert? Now, if you have a state prosecution, you've got a problem if the testing lab is a state lab. That's why in the O.J. Simpson case, they used Cellmark. Cellmark was out of the state of California, and the California labs are too attached to the California prosecution, California Police Department, the state of California, and those labs aren't reliable enough, they're not independent enough from the state prosecution. In tonight's question, we have a California lab doing a California test on heroin. We have a state prosecution problem. Okay? Now, authentication of writings. They've not done writings in a long time. Doesn't mean they won't do it. Take a look at it. We've just done logical relevancy. Now, some of you have learned to always do legal relevancy. Okay? I am not a big fan of it, but you can, if you want, say legal relevancy is the prejudicial impact outweighed by the probative value. But the real issues of legal relevancy are character evidence. Character evidence is evidence that says that because of who you are, you're more likely to behave in conformity with your character. The courts don't like character evidence. They don't like it, and I don't blame them. You know, let's say we think that all people who are green always drive drunk. Well, the fact that you're green doesn't mean you were driving drunk. Might be St. Patrick's Day, but it doesn't mean you're driving drunk. So, what I'm saying to you is they don't like it. And the reason that they can't get a lot of past stuff in on things is because they don't think because you did something before doesn't mean you did it this time. So, character evidence is basically inadmissible. On this bar, character evidence is inadmissible because of legal relevancy problems. It's prejudicial unless you find an exception. And look to see whether you're in a civil case. If you're in a civil case, an exception to character evidence is where character is an ultimate issue. Character is an ultimate issue in child custody, defamation. Now, remember I told you I tried child custody cases and I did sexual abuse. Now, they got evidence in that the mother who was trying to, present herself like Mother Teresa instead of just a regular mother who's flawed and, danced with a G-string at the wedding and accepted dollar bills. That got in. Okay? That's character evidence. If this had been anything else but child custody, it would have never come in. Of course, that was another time when I wanted to do slap therapy on the witness. Yanked her off the stand as fast as I could get her out of there without looking like I was going to literally grab her by the hair, and told her to never not tell me things again. Do not hide things that you danced naked at your own wedding. You think this isn't going to come up? Do not hide the fact that, you were at some private booth and had sex under the table. I am like your pastor or your priest. Tell me everything. Let me decide how to manage it. Because if you know it, you can prevent it by saying, even though you're a freaking goofball for dancing, it's a special wedding and, it was before you had children and you'd never do it again once the child was born, blah, blah, blah. Well, you almost lost the case right there. Learn acting skills, because I just look like, and meanwhile I'm going, oh, for hell's sake. And make sure your clients tell you stuff. Child custody, it's going to come in. Defamation, it's coming in. Character, why? The court believes that the safety of the child, the best interest of the child is more important than the prejudice at this point. Okay? It's an exception to the character evidence rule. Knowledge of another's character. You have a 16-year-old kid, he's a terrible driver. He's driven with his friends and smashed the car up twice and they've been drunk driving. And you say, oh, you got a B- in science. I'm so proud of you. Here's the keys. And he kills somebody drinking. Usually character, but you have knowledge of your child's character, and if that's the issue, it comes in. And the last area is impeachment. And let me say this to you, character evidence crosses with impeachment. If they are introducing character evidence, bad character for truthfulness and veracity is character evidence. A reason that you're not truthful, dump the rules of character evidence, click in your mind, and go to the rules of impeachment. Because there's limitations on introducing impeachment testimony for bad character for truthfulness and veracity. Like, you can only ask them about unconvicted bad acts. You can't extrinsically impeach. So as soon as you know you have character evidence for impeachment, say we have head note character evidence. Character evidence is being used here to impeach. We now need to determine if this is proper impeachment, so that you're not jumping from character to impeachment back and forth. Okay? And practice this. It could be a little tricky. Now, this is a civil case. In a criminal case, character evidence is not admissible unless, number one, you're introducing character of the accused, the mercy rule. If the defendant introduces evidence of his good character, which you pray that he's going to do, or she's going to do, it opens the door for you to introduce instance of bad character. No specific acts. Reputation and opinion only. So if they introduce evidence that they got straight A's in their Catholic school, and that they were, the valedictorian and the highest person for community service and the greatest person on the planet, you cannot introduce evidence that they stole $20 out of Sister Teresa's habit pocket. You can introduce evidence that they were a bully on the schoolyard, kids were afraid of them, he was stealing and carrying on and being a royal pain in the ass. Okay, now, take a look. Both California and the FRE allow introducing of reputation and opinion on the mercy rule, but no specific acts. Those are the same. Now, character of a criminal victim. Sometimes the defendant wants to introduce evidence of the victim's character. Take a look at the rape case. Where was that college rape case? Duke. Duke, remember where they said she was a, what are they called? What kind of dancer? An exotic dancer. Okay, and they introduced the victim's character. Now, be very careful. Type of character evidence allowed. Now, the FRE allows reputation and opinion, no specific acts. California's use of opinion, reputation, and evidence of specific instances of conduct, but the accused are allowed to use evidence of the victim to prove the victim's character is circumstantial. Make sure you look at this California rule. California really usually avoids specific acts. California doesn't like specific acts either of the victim, but they'll allow it under special circumstances. So California is like the FRE, but they'll allow specific acts in if it's relevant and under certain things. Now, character of the criminal victim for violence. Now, the CEC, the accused may show the victim has a character or trait for violence. When would you introduce that the victim has a character trait for violence? Self-defense. Self-defense. If you got somebody who has a character trait of being, I'm going to give you an example, battered wife, battered girlfriend, battered lover, battered somebody, battered husband, has a reputation for sleeping with everybody on the football team. And therefore, with football player, who was that? Basketball player, Kobe, that because she slept with the entire basketball team, she consented to sleep with him. Okay? You cannot introduce evidence of past sexual conduct of a rape victim to prove consent. Okay? Now, you can introduce specific instances. You can introduce character evidence, prosecutor's rule, to show that this killer always ties a bandana around the victim's head. And that's under the mimic rule, motive, intent, common scheme, plan, or design. Under mimic, you can use character evidence, and you can use specific acts. It's like a serial killer has a trademark. Okay, you can use that to show that that killer killed here. And you can use character evidence to impeach in a criminal case. And again, you're going to dump character and go to the rules of impeachment. Now, sometimes people confuse character evidence with habit evidence. It's not the same. Habit evidence is to show that Leonard always exercises his dogs before he puts them in his car. Always, on every occasion, he runs his dogs into the ground before he puts them in the car. And you could use that to show habit, to show that it's likely that when Mrs. Smith says that the dog attacked her because he was all hopped up, you can show his habit is to wear the dogs out to the point that they can hardly walk before he gets them in the car. And the truth is, Mrs. Smith, even though the car says, warning, police dog, put her hands in the car and went, nice doggy, cute doggy. Okay? Habit evidence will show what his habit is. Now, in California, the rule is specificity and regularity. Use those words for the CEC. California requires for habit specificity, thank you, and regularity. Okay? Now, the other area where character evidence comes in is where evidence is relevant, but for public policy, they don't like it. Because they want to encourage people to do these things. It's relevant, but they don't like it because if you punish someone for doing some of these things, they won't do it. And the public policy ones are on page 18 and it's offers to settle. They want people to make offers to settle without it being used against them as an admission of guilt. They want people offers to pay medical bills. They want to encourage guilty pleas. Remedial repairs. They want people to fix things. Okay? Now, if you want to show there's this issue about liability insurance. Basically, you don't want someone to say, don't worry, I've got insurance, as being used against them that they were at fault. However, you can use liability insurance if the ownership or control is disputed. If you say, I don't own that Corvette, and it shows that you have liability insurance on that Corvette, it can be used to show ownership. But basically, public policies, they want people to get insurance, and they want people to carry it, and they don't want it to be used against you to show you're at fault. These policy issues used to be tested ad nauseum, much less tested now. They like other stuff. But sometimes they go back to old stuff. Now, that's the P. And remember, we have logical relevancy, which is proves or disproves disputed fact to consequence, and legal relevancy, where it's logically relevant, but it's kept out, either for public policy to encourage it, or they don't like it because it's prejudicial character, or they want to introduce evidence of pictures of 72 stab wounds, and it's more prejudicial than probative. These are all part of legal relevancy. We're now moving on to the R part of profit. R is reliability. Testimonial competency on 19. All witnesses under the FRE are presumed competent. Yeah. First and say it does tend to prove or disprove a disputed fact of consequence that the car with license plate number XJ7 ran the red light. However, there's an issue here as to whether it's legally relevant. And the issue of legal relevancy is it says, I'm one easy mama RXJ9. Well, does the fact that you say I'm an easy mama, can that be used to show that you consented to sexual relationships with the football player? I see. Yeah, absolutely. You can say. So his question is, let's say you have a photograph with the stab wounds. Photographs showing the 27 stab wounds, if there's a certain angle, does tend to prove or disprove a disputed fact of consequence that the victim was stabbed a certain way and probably stabbed by the knife owned by the defendant. However, had no legal relevancy. Under your California CEC 352, this may be seen as more prejudicial than probative, and therefore, even though it's logically relevant, the court can still keep it out. That's exactly how you do it. Good question. Okay, let me move past. We're on reliability. There's only two issues on reliability. Testimonial competency. Under the FRE, all witnesses are presumed to be competent. Under the CEC, it retains the common law standard that the person must be capable of narrating and recognizing the duty to tell the truth. And what they do in California with children, and this mostly comes up with children or the elderly, is to say, you know, if you've got a trial witness, you say, now, is it a good thing to tell a lie? No, it's not a good thing to tell a lie. And do you know the difference between a fib and the truth? Oh, yes. All right, how do you know? Well, you know, I split the candy bar with Joey, but Joey told his mother that Haley got the whole candy bar. That was a fib. That wasn't the truth. Children have to understand the need to tell the truth and the difference between the truth and not truth. Now, the problem with kid witnesses is any lawyer not completely drugged or alcohol out can take a kid out on the witness stand. You know, you can get them confused, you can get them to, I mean, it's the horrible. You know, I mean, they're little, they're scared, it's a big courtroom. I mean, getting a kid to get confused, getting a kid to not remember what they were saying is like really easy. So if you ever work with children, you need to prepare them for a shark. Sometimes they do closed circuit television and all that, but not all the courts have it. Okay. Also, in some courts, California, every person irrespective of age is qualified to be a witness, but You have to have a child promise to tell the truth, and you tell, in California, everyone takes an oath. I promise to tell the truth. And you either put your hand on a Bible. If a Bible is offensive to you, you put your hand up, or you put it on something else. Because some people are atheists, some people, not everybody's Christian or Jewish, some people, worship other things and other documents, the Quran, the words of John Smith, depending on what you are. Okay, now, best evidence rule is the only second area in the O part, in the R part. Best evidence rule, the best evidence rule doesn't mean this is the best evidence. The best evidence rule means the original writing rule. The original writing rule. And the original writing rule applies if you are going to, if the words have independent legal significance, words of a contract, words of a will, you must produce the original or show it to be unavailable. If you are actually offering a physical writing into evidence, you must produce the original or show it to be unavailable. Or if you're testifying as to the contents of a writing, you must produce the original or show it to be unavailable. What is the original? The original is the writing itself. Admissibility of duplicates, take a look. Establishing unavailability, too cumbersome. Let's say we're testifying to the contents of a headstone. One of those old East Coast, what are you going to get the mortician in and drag the headstone in by bush garden ponies? You're going to have to show it to be unavailable. Now, there's also an order of secondary evidence, and the order of secondary evidence is a copy, a certified copy. The worst evidence is testimony. The worst evidence is people testifying as to what a writing says. That's the third word, copies, emails, duplicates. Some things are considered the originals. PR, we're on O, which is opinion. Heavily tested. Lay opinion. The most important thing about lay opinion is it must be based on personal knowledge. They test this over and over and over, and what is within our personal knowledge? Do we know when we smell alcohol? Yes. Is it within personal knowledge that somebody's a smoker? Yes. Is it within personal knowledge that it's raining? Yes. Is it within personal knowledge that you think John Doe killed Sam? No. Personal knowledge. You have to be there, see it, know it, or it's within your personal knowledge. And personal knowledge is common. Okay? Now, expert, heavily tested. An expert, you need to have a need for an expert. Under the CEC, you don't need a need, you just need to have it sufficient beyond common experience. You don't have to show need, but you have to say it's beyond common experience. And an expert would assist the trier of fact. You have to show what the expert's testifying to, the state of the art. Certain things, like lie detectors, are still not really admissible. The state of the art still doesn't make lie detectors very admissible. The expert's qualifications have to be established. I used an expert one time who never told me where she got her PhD. Do I know she got her PhD from Betty Crocker Inc. University? I mean, she was some famous person, and her PhD was from this was before the internet. This was way before. This was like, you too can be a PhD. It's like Dr. Laura Schlesinger's PhD is in physical education or something like that. She's not a PhD in psychology. She's in, it's not even sports medicine. I'm not even not sure it's physiology. It's more like phys ed. Physiology's really uptowning it. Okay, it wasn't physiology. That's pretty good. Hers was like in, dance movement or something. Which God bless dance movement, but it certainly doesn't make you, the expert on, life and whether, homosexuality is against God, which is basically how she got taken down a few notches. Lost her television show. Yay, double yay. Prejudice on any form about anything is unacceptable. Whether it's prejudice about how old you are, the country of origin, the language you speak, the religion you practice, your height, your weight, All of us want to be loved for who and what we are. We're all the same inside, and we're all one. Ignore that outside crap. It doesn't get you anywhere. It doesn't let you know anyone. It doesn't help you understand anyone, and it doesn't help you know or understand yourself. I don't see it. It's always BS to me. I don't see it. Somebody says, oh, did you notice so-and-so was, gained 15 pounds? Huh? They did? Oh, did you notice that he's African American? He is? I mean, it's not like I'm stupid or I don't notice, but I don't see that stuff. You notice he's Jewish? No. That stuff, get past it in life. It'll make your life beautiful and wonderful. Love is love. Doesn't matter to me. I fall in love. I don't see the rest of the stuff. I mean, if somebody's an idiot, hopefully I'll see that. If they're, gun-carrying gunslinger, I hope I notice that. But I just mean like that external stuff, how much money somebody earns, what they look like, where they live, what kind of car they drive. Is their dog big or small? Is their mother nice or not? Yeah, mothers are important. I do notice the mothers. But you know what I'm saying. Get past that superficial stuff. I know you're young and that stuff seems really important, but it's not. Lead with your heart. And how did I get there? State of the art. I know qualifications of an expert. Dr. Laura, she always gets me off my game. Okay, basis of the expert opinion has to be a matter matters not in evidence or inadmissible evidence can form the basis for an expert's opinion. If they relied on it by experts in the field, they can respond to hypothetical questions. If this occurred, what would your opinion be? That's a good way to trap up experts. Cross-examinations of experts. You can cross-examine about qualifications, basis of opinion, source materials and treatises. If they relied on something. Ultimate issue, they don't want you to ask the expert, well, do you think he's the molester of this child? They don't want you to ask the ultimate issue. That's for the trier of fact, not your expert. That's opinion. Lay and expert, that's it. And they test it, they like it. We're now on the P, privileges. Okay, privileges, basically privileges is the CEC. The FRE has some stuff on privileges, but most of the time they rely on the states for the privileges, although the FRE is adding privileges and privileges about certain information. Now, the most important thing about privileges is that number one, is there a privilege relationship? Number two, is there a communication? If your husband comes home with scratch marks all over him, is that a communication? Yes? I'm not sure. No, but I'm not sure if that's privilege unless you can show in the sanctity of the marriage he wouldn't have felt free enough to come home looking like he's been in a cat fight unless he counted on the fact that you weren't going to blab about it. But, is physical evidence a communication? Okay? Now, was it intended to be confidential? Was there intent for it to be confidential? And this, your eavesdropper problems. Now, if somebody works for you, they're your law clerk, and you invite them in to take notes about attorney-client, it doesn't destroy the privilege. But, if somebody is telling you at a crowded restaurant that they murdered Ron Goldman, and they're, talking pretty loud and the tables are this close, is that intended to be confidential? Okay? Who's the holder? Very important. Who holds the privilege? Because only the holder can waive the privilege. The non-holder can assert it, though. Joint holders. Now, the privileges they're testing on this bar, attorney-client is tested in evidence, but also in PR with duty of confidentiality. Okay? The client's the holder. Now, it used to be that the privilege, did the privilege used to survive if somebody died, did the privilege survive the dead person? Did it used to be where the privilege survived the dead person? Not really. If the person died, the privilege died. In California, they've changed that the privilege survives the decedent. I mean, you're probably young in law school, you just had it, but years ago, the privilege, because I remember I knew the therapist that had been treating Nicole Brown, and Nicole had said something, and when Nicole was murdered, the therapist testified, and the therapist got in big trouble because the privilege survived the decedent, and she didn't realize that. She got her license taken away for a short period of time. God, I know a lot of therapists. Why is that? No. All right. Corporations, who has the privilege? And, there's no privilege if, someone's about to commit a crime. And if the litigation's between the attorney and the client, it's not privileged. If you're trying to collect your bill or whatever, that's not privilege. Physician patients, the other most heavily tested privilege. Okay, and the question is it for diagnosis and treatment, and who holds the privilege? And they don't apply in criminal cases. The privilege does not apply in California to criminal cases. Doctor-patient. Psychotherapist patient, they have not tested on this bar. Clergy privilege, I haven't seen tested. The one they test the most is confidential marital communication privilege and spousal immunity. They test that constantly. Okay? Confidential marriage communication privilege, both spouses are the holder. Both can assert it, but it has to be during a valid marriage. It exists even after dissolution of marriage to communications that took place during a valid marriage. Any communication that happens after you're divorced is not privileged, unless that communication happened during a valid marriage. Great crossover in community property. Nonverbal conduct is just what we talked about. If the observation was made possible by reliance on the marital, then it's privileged. But mostly, there's an exception there. Now, spousal immunity. Spousal immunity terminates on divorce. So if we have a confidential communication during our marriage and now we're divorced, I can testify against you. Now, the spousal immunity privilege belongs to the witness spouse in the federal courts. The witness spouse. The witness spouse. So if you and I are married and I want to testify against you and I'm the witness, it applies to me. I can waive it. I'm the holder. Same thing in California. It's the witness spouse, but the majority rule is that it is the defendant spouse. But in California and FRA, the witness spouse can waive it. They figure if you're ready to destroy, your marriage, go for it. Now, this privilege does not apply in spouses that sue each other. Yeah. Say that again. In California and the FRE, the privilege of spousal immunity belongs to the witness spouse. Common law, it applies, or in other jurisdictions, it applies to the person that's trying to stop the witness spouse from testifying, the non-witness spouse. Now, California FRE just say spousal immunity, the privilege applies to the witness spouse. They're the holder and they can waive. And the non-witness spouse cannot stop you from testifying. Watch what you say, y'all. All right. Also, the privilege against self-incrimination is tested in crim law, crim pro. You have a privilege against testifying to incriminate yourself. It is only testimonial. So let's say you have scratches on your arm. The other attorney can say, roll up your sleeves, Mr. Jones, and Mr. Jones cannot claim Fifth Amendment privilege against self-incrimination. Because why? It's not testimonial. It's physical. Fifth Amendment only applies self-incrimination, testimonial evidence. They ask that a lot. Okay, P-R-O-P, we're now on H. Okay, and you got to understand this is quick, this is fast. Evidence is rule heavy, Do not be worried about being conclusionary in evidence in the sense of rule facts, rule facts, rule facts, rule facts. Because some of these have 5 elements. Some of these hearsay exceptions have 4 elements. You're not going to go on and on about your factual application. Your head note is your issue. In evidence, do not be saying, at issue here is whether this is hearsay. Forget about it. Head note, hearsay. Make sure you spell hearsay, hearsay, not heresy. I've read 10,000 heresies. There are about 15 words the bar must know you know how to spell. Defendant, plaintiff, separate, S-E-P-A-R-A-T-E, not separate. Don't say hearsay. Hearsay. I know you're laughing. I'll read 20 evidence questions that's going to be misspelled as heresy. It's heresy to misspell hearsay. Okay? If you have time, but the problem is some of these don't have legal dictionary spell checks, so it won't recognize. If you have time, of course, do a spell check. I wouldn't carve out time to do it. I mean, if it's a typo, they can pretty much tell. But, memorize how to spell basic legal words. Judgment. Foreseeability. Hearsay is one of them. I want your head note hearsay, and this is what I want under hearsay. Hearsay is an out-of-court statement. Parentheses, this was made in Sarah's backyard. Being offered to prove the truth of the matter asserted. Parentheses, offered to prove the truth of the matter that the red car ran the blue light, that the blue car ran the red light. Okay? I want you to define it, and I want you to apply it every time. And you need to be careful that it is, in fact, only relevant if it's true. In other words, some statements are important because they were said, even if the truth isn't important. Hearsay is only hearsay if it's being offered to prove the truth of the content of the declarant statement. Some statements are important because the person said it. We don't need to prove that they actually mean it. We just need to prove that they said it. If we're trying to prove that the truth of it, it's hearsay. If it's important for any other reason other than its truth, it's not hearsay. Okay? Example, I think I am the King of England. That may be important to prove that the client is insane, but we're not trying to prove that the client is the King of England. Understand, we may introduce it for other reasons. It may be important because it was said. It may be important if somebody said, I think, I don't want to say that, but it would be a good one. Never mind. Hearsay. Now, multiple hearsay. A bar, the last time they tested evidence, they had multiple hearsay. The best thing you're going to do with multiple hearsay is you're going to divide and conquer. You're going to separate out the statements. A to B, is it hearsay? Are there any exceptions? B to C, head note, is it hearsay? Any exceptions? In order for the whole statement to come in, both ends of it have to have exceptions. If one doesn't come in, the whole thing doesn't come in. So if I say to Chris, last night I saw a man with a blemish on his arm kill the dog next door. Okay, and Chris writes an email to John and tells John that. So that whole, and John comes in and testifies that I got an email that said the neighbor next door killed the dog next door, and how did you find out? Well, Chris told me. Chris, it has to be hearsay, out-of-court statement offered for its truth with an exception, and your end of it has to be an exception too. Otherwise, the whole thing goes out. Now, you can be very fast in court because if you find out A to B has no exception, then you don't care. The other attorney is going to be arguing that B to C is has all these exceptions, and Your Honor, I don't care. A to B doesn't have an exception. This thing doesn't come in. Counsel, you're right. Sit down. So, multiple hearsay. You tell a police officer sees something, they put it into the record. You understand what I'm saying? Check each end of it. You to the police officer into the hospital record. Both ends have to have an exception. Okay? Otherwise, all hearsay would come in because you'll tell someone else and that part comes in. They don't like hearsay. Why don't they like hearsay? I mean, it's not that they don't like it, but why does hearsay have so many hoops? Basically, it's inadmissible because the declarant, the person who said the statement, may not be in court, right? We're testifying as to what someone else said or what we said at another time. You don't have a chance to cross-examine them, especially if they're dead. You know, you could always say, yeah, when he was dying, he told me that the accident was his fault. Well, you can't cross-examine the person who said, yeah, the accident's my fault, because they're deceased. You know, there's problems. They're not reliable, and you often can't cross-examine the person. So, hearsay is something that the courts, you have to have an exception to get it in. It's basically inadmissible, okay? There are some exclusions, some hearsay exclusions, which is, the statement's important because we're trying to show state of mind of the declarant. I'm King George. State of mind of the listener. Prior statements to impeach or rehabilitate are important because they're used for impeachment, and words of independent legal significance are not hearsay. We do want to know that the contract said, I make an offer. I'll take this in a minute. Hearsay exceptions. Here's the mnemonics for hearsay exceptions. Adam, P, Bop, C-I-C-I. So let's go around the room. What is the A for, Manny? An admission. What is the D for? Declaration against interest. What's the D for? Keith. Keith. What's the D for? Come on. Dying declaration. Good. Ramona, the E. Excited utterance. M. Claudia. Mental state. P. Alex. Physical state. B. Sydney. Business records. O. Tiffany. Official records. P. Doug. Past recollection recorded. P. Theo. Prior testimony. Good. S. Brian. Sense impression. E. Kelly. All right. E. That's equivalency. I. Identification, prior identification. C. Bartak. Consistent statements. I. John. Inconsistent statements. So it's Adam, P. Bop, C-I, C-I. Again, if you get this, great for the bar, great when you're in court. You can buzz through these and come up with whether it comes in or out very quickly. You could be really awesome. Now, let me go through the ones that are heavily tested. An admission. Under the FRE, admissions are non-hearsay. Under the California, they're hearsay, which are words or acts of a party offered against that party. If Michelle says to me, I like to drink every night, and you have a car accident, those are words or acts offered against you, okay? Adoptive admissions. An adoptive admission is somebody, there's a couple of ways to get an adoptive admission, but usually they're admissions by silence. So let's say I'm in the car, and you and I have committed a bank robbery, and Sanaz says, yeah, we planned it. I've got a baby at home. I needed the money. And Joan, it was Joan's idea, and Joan is the one that provided the murder weapon. If Joan is in the car and you're in the car and you say that, and Joan doesn't say, I never said that, that's not true, and says nothing, it could be considered an adoptive admission, which is an admission by silence. Okay? And in order to have that, on page 33, the party must have heard the statement. The party must have been capable of denying the truth. In other words, she wasn't knocked out, shot, bleeding in an ambulance. And the circumstances must have been such that a reasonable person would have denied the statement if it wasn't true. Okay? Vicarious admission is statement by a non-party imputed to a party. And it has to be an authorized representative, co-conspirator in furtherance of the conspiracy, a predecessor in interest, or a decedent in a wrongful death action. Okay? Vicarious admission by agents. FRE, if an agent or a servant concerning a matter where the course and scope of the agency makes a vicarious admission during the existence of the relationship. So the truck driver that works for a trucko says, it was my fault. I didn't see the child run across the crosswalk. That admission is going to be held against the employer as a vicarious admission. Okay? The CEC, the authority of the declarant to make the statement does not have to be expressed. It can be implied from their relationship. Okay? Vicarious admissions by co-conspirators is heavily tested in crim pro and crim law. Very heavily tested crossover with evidence. And this is where my situation with Sanaz, where she says something and it inculpates Joan. You're going to have the Bruton test on this one, but you'll get Bruton in crim law, and you might have already gotten there. The Bruton test basically says that if people, it requires that part of the record be redacted. If it's a problem when she says a statement that inculpates her, and now we're using it at trial. Joan didn't make the statement. Sanaz did. And if she's being tried for that crime, Sanaz's statement's going to be held against her. So there's some constitutional problems with that. Now, declaration against interest, hardly ever test it. Dying declaration, occasionally test it. A dying declaration must be, number one, by a person now unavailable. They're probably dead. Respecting the cause and circumstances of what they believe to be their impending death. Sometimes they think they're dying and they're not. And the statement was made upon personal knowledge under a sense of impending death. The FRE limits dying declarations to homicide prosecutions. And the CEC, the declaration... Okay. And, well, I want to finish this. Hold on. Are you dying here, or do you need to do dying? Can I finish evidence, or you need a break? How many want me to finish? How many are dying? You can say if you're dying. It's not a bad deal if you're dying. Those that are dying, stand up and stretch a little bit while I go on. In fact, take a 2-minute break. Everybody stand up. Because I want to get through evidence before. Asked how many of you wanted a break, and the truth is all of you wanted a break. Because every one of you stood up, got a snack, did something. So Leonard whispered in my ear, he said you needed a break. Because he's in your minds and knows everything. But also, make sure you speak up and step forward. I don't think badly of you if you need a break. If we need a quick break, you need a protein bar, you need something, that's cool. You're tired, you're studying. I'm not offended by it. We're almost done with evidence. Okay, good. You're doing good. If you need to stand up, stretch, good. So I applaud those of you that were honest about it. But you all needed a break, it seems like. And when we're done with evidence, I'm going to give you a little bit longer break. And then I'm going to do the question, and then we have con laws. So that's why I'm kind of, and we have Leonard I'm trying to get him to do it at 9:30 so you're not so tired and overdrawn about it. Okay, good. Dying declaration, not very heavily tested. Excited utterance, extremely heavily tested. Extremely heavily tested. Under the FRE, it has to be of and relating to a startling event made while the declarant's under the stress of the excitement caused by the event. That has to be memorized. Okay? Now, sometimes on these hearsay exceptions, you can just list them. Go 1, 2, 3, 4, rule facts. Or you can do the rule of element 1, facts, do the rule of element 2, facts. Get in, get out, though. You're not going to be romancing the stone this time. Because you're not, this is a racehorse. Get in, get out, boom, boom, boom. Now, the CEC is different on this. California requires spontaneously. So if I say 5 minutes, let's say it's Tess, and there was a bar question on this. 5 minutes after Tess was raped, she ran sobbing to her neighbor. Under the FRE, it's of or relating to a startling event made while under the stress of the event, caused by the event, it comes in as an excited utterance. In California, it doesn't come in. It's not contemporaneous. It's not spontaneous. Contemporaneous means while she's being raped, she's going to have to say, "Help, I'm being raped," for that to come in. It's craziness. So it has to be offered to explain or make understandable was made while the declarant was engaged in the conduct. So, on the bar, say, under the FRE, 5 minutes would not be too long. It was made while under the stress of the startling event, at or relating to the event. Under the CEC, it must be contemporaneous. Okay? And you got to practice these because it's tested all the time. Mental state, not too heavily tested. Physical state, remember, for physical state, the statement has to be made to a doctor or to whomever for the purposes of diagnosis and treatment. It can't be introduced for the purposes to show that he's a crack addict or to show that he's trying to deal drugs or to show anything, okay? And the statement can't be made in contemplation of litigation, and it does not need to be made to a doctor, okay? Business record, heavily tested. You just need to memorize the elements. Business record made under the transactions fresh in the entrance mine on 37. Regarding facts within personal knowledge, part of the regular course of business, record is properly authenticated. Test it all the time. Now, Leonard, sometimes they pay attention more when I move around, but then it's hard to do other things. I'm almost there, though. Under the CEC, it does not need to be in the regular practice of the business activity. That's the difference. Official record, you can look at the requirements here on 37. Made by a public official. Matters regarding personal knowledge. Recorded in the course of business public duties at or near the time now. You can't have, like tonight's question, where it just says stamped, official report, A. Smith. Don't fall for that. All right? Now, okay. Past recollection recorded, sometimes not very heavily tested. Prior testimony, not as heavily tested as it used to be. Present sense impression, it used to be when they tested the FRE that if it wasn't an excited utterance, under California, it wasn't an excited utterance, but it might be in California a present sense impression. Now that they're testing California directly, forget it. Present sense impression doesn't have to be an exciting event. It can be, oh boy, there goes Mrs. Jones with the dog on the toaster. They must be getting a divorce. Okay. Now, expert treatises, it used to, expert treatises are hearsay exceptions because sometimes they want to introduce them for information. Sometimes people testify to them. Let me tell you something. Equivalency is never the right answer. It is never the right answer on the multi-state. It is never the right answer on the essays. If you have found no hearsay exceptions, do not let it in on equivalency. It doesn't come in. Do not umbrella, do not equivalency. All right? Now, under the FRE, identification's not hearsay. It's out-of-court ID. Yes, that was the man with a brown blemish that I saw running down the street. Non-hearsay under the FRE, hearsay with an exception under California. Okay, consistent statements, non-hearsay under the FRE. Inconsistent statements, non-hearsay under the FRE. So you've got somebody that gets on the witness stand and you get him to testify that they testify to the fact that they would never hit their children, that they love them. And then you get either another witness who says, I used to hear the kids, she used to slap the kids around every time I looked out the window. Or you get the witness itself saying, well, I never believe in hitting kids unless, and then she spills her guts, or he spills her guts. You can use that to impeach them. It's non-hearsay. Okay, now, examination impeachment. Okay, impeachment is basically direct and cross-examination. These are where most cases are either won or lost. How good you are at direct and how good you are at cross is how good you are as a lawyer, basically. Because when I first got out of law school, I thought that if I could testify to it better than the person on the stand, I'm the one that should be saying it all. And the judge would get on me constantly going, do you want to take the stand instead of your witness? Because you, counselor, are doing the testifying here. Okay? So the trick is to get your client to say it without leading them, which I always say, but they don't like it. So I gave you all the form objections over here too, but that's for cross-examination. Okay, impeachment. There's two ways to cross-examine somebody. Impeachment, you either get the witness to say it out of their own mouth, that's intrinsic, or extrinsic, where you bring in records, other testimony, scientific, anything, and it's not on the witness's own mouth. Okay? So, for intrinsic impeachment, you impeach someone for bias to show they have... Now remember, to impeach, the person has to be on the stand or has to have taken the stand in the fact pattern. You can't impeach if they haven't taken the stand. I've seen more people write about impeachment when the person never testified. To impeach, the person's got to be on the stand. Okay? So, you can impeach a witness for bias, a reason to lie, a reason not to like the person, a reason not to tell the truth. You can impeach with a prior inconsistent statement. But isn't it true, Mrs. Jones, that you testified to just yesterday that you never once hit your kids? Now you're telling us today only when they deserved it? Which was every day? Which is it, Mrs. Jones? I think the latter's better. I don't know if I told you the Girl Scout cookie. I did a show, and we were on the Girl Scouts, and that she bought 120 boxes of Girl Scout cookies. Okay, and the Girl Scouts were suing her for the $600 or $800 for all the cookies, and she never returned the boxes and never returned the money. So she says her story was that ants got into the Girl Scout cookies, and that's what happened. Ants ate 120 boxes of Girl Scout cookies. They sound like, an old, Attila the ant, And I said, how many ants, how big were they? Were the size of a nickel, a quarter? Were they as big as this? And she was a little bit husky. So I thought, I wonder if she ate the Girl Scout cookies. So I said, well, how many boxes did you eat? And she said, well, not that many. So I said, was it more than 5? Was it more than 20? Was it more than 100? Well, it was a little less than 100. I was fishing. And I hit home. And I said, was it more than 85? Well, I'm not sure. Well, what's your favorite flavor? Well, I sure like those chocolate mint and those peanut butter. How many of those 120 were chocolate mint? I don't know. I ate them all. So, isn't it true? It wasn't the ants, it was you? Well, the ants, I said, did the ants get any crumbs? Did the ants even get paid? Did the ants get anything? Well, a few boxes went to the ants. So, you didn't give them back to the Girl Scouts. You ate them. It's fine if you ate them. Nobody can accuse you of, not liking Girl Scout cookies. They're quite good, but now you got to pay for them, ma'am. And that was the story. So, I got her to spill her guts on cross-examination with a prior inconsistent statement. The other thing is you need intrinsic impeachment. This is where you get stuck. Well, one is bad defects in memory, whatever. Mr. Smith, how far were you when you said you saw the accident? I was 100 feet. Isn't it true, Mr. Smith, that you wear glasses? Okay, Mr. Smith, can you see me here? Yes. How many fingers am I holding up, Mr. Smith? 3. I am now 100 feet, Mr. Smith. How many fingers am I holding up? I can't see. So you mean to tell me you could see the license plate on the car when you can't even see how many fingers I'm holding up? Isn't it true you need glasses and your vision is 200 over 800? Yes. This is a good one. You couldn't see, you couldn't hear, you couldn't smell, you couldn't. Defects in memory, vision, capacity. All right? Bad character for truthfulness. This is the one the bar tests very heavily because it crosses with character evidence. You're trying to basically say that your witness has a bad character for telling the truth. You're basically saying to the judge and jury, this person's a liar. Don't believe a thing he says. And bad character for telling the truth, you have to distinguish between convicted and unconvicted acts. Now, if it is a convicted bad act, the federal rules require you can impeach for any felony not older than 10 years old. You cannot in California impeach with misdemeanors. You can, under the federal rules, impeach with a misdemeanor if it involves bad character for truthfulness. I don't think you can impeach in California with misdemeanors. In a criminal case, right? I have to check that. Will you check that and email it to me? In a criminal case. All right, this has to be edited. Hold on a second. So give it to me. A misdemeanor? Okay, in California, witness can be impeached with a misdemeanor that involves moral turpitude, but it has to be a criminal case. Only in criminal case. And what's the case? I got to check that, but I think you're right. D-U-R-H-A-N. D-U-R-A-N. All right. People v. Duran. Hold on. Yeah, I thought that was right. I have to check this. But there might be a case that's been codified in the last, I don't know when. I'll check it for misdemeanors in California. Hold on. I'll check it and I'll get back to you. Misdemeanors. Says. Right, just what you said. In criminal, you can impeach with a misdemeanor. In civil, you cannot. Okay. All right, so here's the rule. In a criminal case, you can impeach with a misdemeanor which involves dishonesty or moral turpitude. In a civil case in California, you cannot impeach with a misdemeanor. Okay. Now, okay, send that, make a copy for me. Okay. Under the FRE, anything over 10 years is probably too remote. In California, juvenile offenses are not admissible for impeachment. You can't impeach for any juvenile. Usually those records are sealed. Okay, extrinsic impeachment is impeachment not out of the witness's own mouth, but you bring in other testimony, you bring in other people to testify about this particular situation. The collateral matter rule does apply. You cannot use extrinsic impeachment, use a witness to talk about a matter that's not central to the case, that's collateral, because it wastes the court's time. Okay? No collateral matter rule under the CEC, but the judge has flexibility. Now, the question on extrinsic impeachment is how much foundation needs to be laid. Do you need to lay a foundation? Methods of extrinsic impeachment are bias. Prior inconsistent statement, you do need a foundation. Collateral matter rule does apply. Defects of memory, capacity, perception, no foundation required on the top of 45. Bad character for honesty or truthfulness. If you are impeaching someone for an unconvicted act, you may intrinsically impeach, you may ask them, you may, but if they say no, you cannot extrinsically impeach. So, if I ask Haley, isn't it true, Haley, that you drive really fast and scare your passengers? If she says no, I can't introduce Doug, who's a passenger, to say, I've been scared out of my mind when I drive with her. I can't do it. Once you say no, I have to stop. But Haley, what I can do is push it a little bit intrinsically. I can get you to talk more, but there's no extrinsic impeachment for unconvicted bad acts. You can't bring in witnesses. You can't bring in, an unconvicted bad act's an arrest. I can't ask Claudia, have you ever been arrested? And she says no. I cannot bring in an arrest record if you have not been convicted. Or if you've pleaded, not guilty or whatever. So unconvicted bad acts, they test this all the time. They test it this whole thing about the powdered milk tonight in that question and that whole deal, you'll see. Okay, misdemeanor convictions, and again, you have the issue of remoteness. Now, testimonial substitutes. For some reason, this bar loves judicial notice. I don't know why. They just love it. They do test it quite a bit. Judicial notice are facts of common knowledge, generally known by a well-informed person of the community. You can also take judicial notice of things that are universally known, or things that are capable of verification, which now with the internet, so much is capable of verification. But it's like, you know, on the O.J. Simpson case, the moon, was it a full moon? Was it a half moon? Could you see? How far could you see? What time of night was it? Was it raining? Was there, you know, judicial notice of the state of the moon and how bright it was in that neighborhood in that time? Okay? And you can also take judicial notice of laws, regulations, legislation, records, and legislative facts. Okay, that's it on the evidence approach. I'm going to give you a short break, then we need to come back and do the question. I have a question for you. I'm not sure if we're going to get through all of con law and the con law question. So I want to go through the evidence question because I think evidence is pretty likely, or, you know, more likely. I want to go through the con law approach. I'll lightly hit the con law question. Tell me if that works for you. Would you rather I go less approach and heavier in the question? How many of you want more heavy into the question in con law? How many approach in con law? Okay. All right, take a break. Take each item of evidence in a column. And the columns are number 1, the California forensic report. Number 2, Tim's testimony regarding the powdered milk. 3, Sue's testimony regarding dating Tim. 4, Sue's testimony regarding Jenks. And 5 is Dr. Walt's testimony. How many of you have not gotten to evidence yet? Because it doesn't look to me like you're going off of any of your own outline. How many have not gotten to this question yet? Hands up, you haven't gotten. A lot. Okay, and you haven't gotten here because why? Running behind or no? Why? Is that why you're not doing the sim exam and so you're, yeah, that's interesting. Okay, so what I'm thinking is that maybe I don't really want to go through this if you haven't really done it. I don't know what good it's going to do you. How many of you have done it? All right, I'm going to go through this. I'm going to go through this a little bit quicker than I would normally if all of you had done it. Okay, but what's going to happen is that I rewrote the sample answer, and Anna's going to make copies for you and give it to you on Saturday. So that'll be good for you. I have the answer, the full answer written out, but I wanted you to have the chart and the outline. So at least follow along with the question. Make sure you do these in columns. Now, something I want to tell you in evidence that's different than the other subjects. You are not going to really be able to, in an evidence question, write a full outline with law and facts. I don't think you're going to have the time to do it. I think you're going to have a very abbreviated evidence outline, which is where you're going to have the issue, what the elements may be, or what the issues are, but it's going to be a quicker outline. Not quicker than 15 minutes. I just don't want you writing too much of what's going to be in your question on your outline. I do want you to outline for 15 minutes, but I don't think you're going to get business records exception and the 4 rules and the facts in your outline. You're probably going to get business records exception at or near the time, personal knowledge, something very quick. Okay? Does that make sense to you? And somebody else, Jasmine asked me a really good question. She said, if you find a piece of evidence is not relevant, do you then not go on and discuss anything else? Once you find it's not relevant, do you stop? No. You say, assuming the court finds that this is relevant, and then you go through the rest of the issues. Otherwise, you're going to write yourself out of 20 points. Okay, starting with this, it's the California Forensic Report, number 1, head note logical relevancy. you're going to start with under California CEC 350, no evidence is admissible except relevant evidence. Then you're going to say evidence is logically relevant if it tends to prove or disprove a disputed fact of consequence. Here, the disputed fact of consequence was whether Tim was in possession of heroin on September 13th, 1984. Use a date if they give it to you. Okay? Since he's charged with possession of heroin, the lab report identifying the substance as heroin is logically relevant. However, in order for it to be admitted into evidence, there needs to be a proper foundation met. It's relevant, but it may not come in. Okay? Just because it's relevant doesn't make it admissible. Now, here we have issues of scientific foundation, right? And this is straight from the book. The first issue is chain of custody. And the issue with chain of custody is that you have to prove the substance was tested by a forensic lab, that it was an unbroken chain of possession from the time the detective confiscated it until it was delivered to the forensic lab. And the problem here is they tell you it took 2 weeks. It was in the lab, or it was in the, he didn't submit it for 2 weeks. Under the CEC, the state must show what the item is, that it's relevant in the case, that it's in a relevant condition, and an unbroken chain of custody. Okay? The facts are silent about chain of custody. We don't know. The prosecution has to show that what was taken from his pocket is what actually ended up in the police, what ended up in the California forensic lab. Okay? So, he placed it in the detective placed it in an envelope, left in the evidence room for 2 weeks before sending it to the lab. Therefore, the chain of custody has not been established, and the report on this ground would be inadmissible. Now, let me say this to you. It's okay with me if you find a different conclusion. You don't need to be right. We don't need to agree on what you got. We just need to agree what the issues are that you have to jump through to get there. So whether you say it's admissible or not admissible doesn't really matter. But because the fact pattern asks you, then the next issue is it hearsay? Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. This statement was made out of court, and it's being offered to prove that the substance that was taken from Tim on this date was in fact heroin. Okay? Therefore, it's inadmissible hearsay unless there's an exception. Head note, official records exception. Rule, official records exception 1, made by a public official or one performing a public function, regarding matters in the declarant's personal knowledge, recorded in the course of the declarant's public duties, and at or near the time of the act. Again, this is your laundry list of elements for, they're very interested in what you're doing, so I guess I'm interested in what you're doing too. Everybody's following you as you walk around. This must be exceptionally boring. Are you exceptionally bored? Well, only the girls are following him. None of the guys even noticed he walked over there. Good for you guys. And girls, you've got good taste. But I really would like to be doing this not by myself, because I actually already passed the bar, y'all. I don't need to pass the bar. You guys do. So pay attention. And if you think I don't notice every single thing you're doing, you're wrong about that. Okay, we also have a state process. Now, this side was very focused, too. He must have a fan club over on that side. You guys didn't look either. All right. State prosecution problem. We have this California State Lab, and we have the problem with whether it's to associate it with the state prosecutor to be reliable and independent enough. Okay. Now, that's call number 1. Look how many issues you have on call 1, and you're 1 of 5. So when I say get your booty in and get your booty out, I'm not exaggerating. Call 2 is Tim's testimony that he possessed powdered milk. It wasn't heroin at all, right? Okay, logical relevancy goes to the disputed fact of consequence. The fact that Tim possessed heroin on May 1st, 1983 does not mean he was in possession of heroin on September 13th, 1984. Watch your dates. We've got a problem here, and the problem is character evidence. Okay? What they're trying to show is because he was in possession of heroin on the earlier date, he was in possession of heroin on this date. Conduct in conformity with character. This is okay. We know that we are in a criminal case, and is there an exception here? Is this any exceptions? Any exceptions apply? Which one? I don't think this falls under mimic, y'all. Because he was convicted earlier, this is not mimic. He had to have done some signature kind of thing, like always had a rose by the pickup of the drugs. I don't see the prosecutor's rule here. They're offering specific acts on 1983 to prove conduct in conformity with character September 84. I don't think mimic's going to work. Nah. This is the reason they have the character evidence rule. Because the guy, he could have been clean and sober, been in AA. We don't want them to be able to use an old conviction to prove this new one. They're going to have to prove this new one on their own. Okay? No, I'm not going to take any questions. Okay, intrinsic impeachment. Okay, intrinsic impeachment, we have an unconvicted bad act. Let me take a look at this question. Hold on. Let me just see one thing here. Yeah, a defendant called Tim, who testified on direct that he was in possession only of powdered milk, is being framed. On cross-examination, Tim was asked, isn't it true on May 1st you were in possession of a half a gram of heroin? They're trying to show by character evidence, conduct in conformity with character. He took drugs before, he took drugs this time, and this wasn't powdered milk, it was heroin. Okay? So, the other issue is they tell you that the defendant takes the stand. So what they're trying to do is they're trying to intrinsically impeach him. You testified in direct possession of powdered milk being from you were in possession of heroin. They don't tell us he was convicted, do they? So we have an unconvicted bad act. We have an unconvicted bad act. They can ask the witness out of his own mouth. Tim answers yes. What a fool. Bad lawyer. Okay? The next issue is cross-examination. Under the CEC, the witness may be cross-examined upon any matter within the scope of the direct exam. Was he asked on direct about this? Nope. Since the direct never argued anything about the May 1st, 1983 heroin possession, they cannot cross-examine him about this. And this is the way people get out. Also, we have a leading question, or you can argue the defendant's a hostile witness, and this is not going to come in. Inadmissible character evidence. Inadmissible character evidence, basically. Okay, we have Sue's testimony that she'd been dating the defendant for a year. On 8 occasions, they dined out. He drank his coffee, and he added powdered milk from a jacket. The issue with Sue's testimony, is it logically relevant? Is the fact that on 8 other occasions he had powdered milk logically relevant to prove on this occasion it was not heroin, it was powdered milk? Okay? The fact that he was not in possession on 8 dates does not mean he was not in possession on this occasion. I would argue that is not logically relevant. I don't care how you conclude. This is character evidence. She's introducing evidence of Tim's good character. She's saying the guy only used powdered milk. He didn't use heroin. Once she opens the door and says this is evidence of his good character, prosecution can introduce evidence under the mercy rule of reputation or opinion of his bad character. Here Sue's testifying as to specific acts. Which, can she introduce under the mercy rule specific acts? Tim? She cannot, under the mercy rule, introduce evidence of 8 specific acts. This evidence isn't coming in. Not there yet. Next issue is this habit. So it's not coming in based on character, and it's not coming in on that. Is this habit? Sue may, however, argue that a foundation has been met that he regularly in the course of dating him always uses powdered milk. It's an eating habit. He observes it every single time. She might have personal knowledge. This may be admissible habit evidence. So despite the specificity of her testimony, that on 8 different occasions, it may come in as habit. It will depend on the judge. It also could come in possibly issue of opinion. And I'm going P-R-O-P-H. It's lay opinion. Does a lay person know powdered milk? If it's within her personal knowledge and she knows powdered milk, it's arguable, it's lay opinion. Now I want to tell you something. Everybody's not going to get all these issues. These were like the issues taken from both answers. These are the possible issues. You may not have had opinion. Some of these, like habit, you need. Some of them, the character evidence, only one had it. Lay opinion, it may or may not come in. Next issue is Sue's testimony that Jenks once arrested her for prostitution and offered to release her on payment of a bribe. Then when she refused, Jenks said, "Just wait, I'll get you and all your friends." So the issue is relevancy. Does this go to a disputed fact of consequence? Yes. Bias is always a disputed fact of consequence, whether somebody is biased against the witness or not. It is relevant to establish bias on Jenks's part. Evidence which shows bias is always relevant. This was generated by Jenks that he had a motive to get Tim. Okay? Since Jenks has testified, his credibility may be attacked by a showing of bias, because it tells you that Jenks testified where? That he was being framed on cross-examination. Culbis, who testified on that Jenks once arrested her. Jenks says, "Just wait, I'll get you and all your friends." Okay, we can assume that he said that. Okay, is it hearsay? Hearsay is an out-of-court statement. The statement was made out of court. Is it being offered for the truth of the matter asserted? I think you can argue here that this isn't being offered for the truth of the matter asserted, that he's trying to get her and all her friends, that it's offered to show his state of mind, that he's biased against her. If it isn't a state of mind exclusion, it may be a mental exception to show that Jenks is trying to get her and her friends. So if it's not being offered for its truth, just to show his state of mind, it's a state of mind exclusion. If we are trying to show that Jenks, in fact, is trying to get her and all of her friends, then it's a mental state exception. Okay, you could have one or both. Okay? The statement is relevant because Tim's main argument is that Jenks framed him and that therefore is admissible. State of mind exclusion, state of mind exception. Okay, we are now on Dr. Walt. Dr. Walt testified that on September 9th, 1984, he examined Tim, who complained of insomnia and anxiety, and then he said he was a narcotics addict and asked Dr. Walt would he like to buy drugs. I thought doctors sold drugs, not bought them. This doctor with this wrestler is in so much trouble. I mean, he gave him enough steroids. What did he give him, like 10 months with how much? Like in 3 weeks? 4 weeks? Is there any of these wrestlers or athletes that don't take steroids? I don't think you can compete without steroids anymore. There's lots, you think? I mean, I really don't, I don't know if you can compete in today's sports without steroids. What are steroids like? I thought they were like prednisone, and is that a steroid? But what are the ones they're giving these athletes? It can't be like that. Like my dog was on prednisone, and he didn't get all buffed out. So, what are these? Really, I thought my dog was like going to get really muscular, and he didn't. I was disappointed. So, okay, the last one is Dr. Walt. So the first issue is insomnia and anxiety. Now the question is it relevant? Arguably, this testimony is not relevant because insomnia and anxiety doesn't go to prove or disprove the disputed fact of consequence of whether the guy was in possession of heroin on this date. Plenty of people are anxious and can't sleep. They may be taking the bar exam. Doesn't mean they're on drugs, right? So I don't even know if this whole thing, this anxiety, insomnia is relevant. But again, Jasmine, you got to bring it in and say, assuming it's relevant, okay, Legal relevancy. The problem here is this is character evidence, right? They're trying to prove what? That he's a narcotics addict in need of money, and that's why he sold drugs on the date the cop picked him up. So, are there any exceptions? Prosecutor's rule, okay? May be used for to show what? Motive, intent, common scheme, plan, or design. Your argument for the early one here fits here. Opinion, expert opinion, possibly Dr. Walt. Must be, they tell you he's a doctor, but he's not a qualified expert. But maybe he's testifying that he's his doctor and not testifying as an expert. Okay? Privilege, doctor-patient privilege. The question is, was this made for diagnosis and treatment? The part about insomnia and anxiety is probably made for the purpose of diagnosis and treatment. Okay, the CEC says that all confidential communication between a doctor and a patient made during the course of the relationship is privileged. The problem is what, Tim? No, no, that's one problem. But what's the other problem? This is a criminal case, right? The doctor-patient privilege doesn't apply in a criminal case. Okay? Now, the other problem has to do with when he says to the doctor, do you want to buy some drugs? Now, in California, the offer to sell drugs is a criminal prosecution, and the doctor-patient privilege does not apply, so that probably would come in and probably kill this guy. This is the worst evidence yet. The question with the anxiety and insomnia also is an issue of hearsay. Out-of-court statement, offer to prove the truth of the matter asserted. He said at the doctor's office, being offered to prove the truth of the matter asserted, that, what? He has insomnia and anxiety, or maybe he's a drug addict. You know, it's a little subtle. It's an admission, words or acts of a party offered against that party. He's saying, I'm a narcotics addict. I have insomnia. Do you want to buy some drugs? Can I buy some drugs from you? Do you know where there's drugs anywhere? The statement cover, you know, the doctor-patient privilege is not going to cover the statement, and the question is going to be whether it falls within a hearsay exception or not. If it does not fall within a hearsay exception, it's inadmissible. If it does fall within a hearsay exception, it's admissible. Okay, that is the long and the very short of this.